I'm SHIVARANJANI GOPAL.
Hi, I'm FANG.
Hi, I'm LOHKATHAMARAI.
Hai, saya THENAGARAN NARAYANASAMY.
Good morning, everyone. Welcome to QTV. Today, our forum topic is the Sedition Act 1948. There are some professionals to talk about the topics.
A very good morning to all. My name is THENAGARAN. I work as a lawyer.
Hello everyone, my name is LOHKATHAMARAI. I work as a lawyer.
Hi everyone, I'm SHIVARANJANI GOPAL here and I'm a judge.
Before the forum starts, let us watch the video first.
Keadaan eksklusif dalam negara kita di masa ini adalah hasil daripada bayat-hati kaum Bumiputera membiarkan sekolah-sekolah Cina dan India menggunakan bahasa mereka selepas merdeka. Sekiranya tokoh-tokoh kita yang awal dapat meramalkan keadaan yang berlaku pada masa ini dan tidak bertolak ansur untuk menghapuskan pelajaran Cina dan Tamil, sudah tentu kita tidak akan menghadapi masalah yang kita hadapi sekarang ini. Bagaimanapun, masih ada lagi masa untuk kita membaiki keadaan ini. Tindakan kita bukanlah mencerminkan tujuan dan kepercayaan tokoh-tokoh kita yang lalu oleh sebab mereka telah bertindak berdasarkan kepada keadaan yang wujud pada masa itu dan mereka dengan ikhlas mempercayai bahawa mereka telah dapat menyelesaikan isu tersebut. Mereka tidak dapat disalahkan dengan apa yang terjadi pada hari ini oleh sebab cabaran-cabaran yang kita terima hari ini bukanlah datang dari zaman mereka. Cabaran yang kita hadapi sekarang adalah tanggungjawab kita untuk mengatasinya.
Please start.
I object your speech, Mr. Coding. We have already gained Merdeka for our country. And what's the use of your speech right now? This issue can bring a racist problem to our country, and Malaysia is one of the multi-ethnic and religious countries. Can you please recorrect your speech?
Saya tidak setuju dengan pandangan anda, Encik Badmanavan. Tuan yang dipertua, masanya sudah tiba bagi Dewan Yang Mulia ini untuk memutuskan sama ada kita akan terus membenarkan sekolah-sekolah Cina dan Tamil dan bahasa-bahasa tersebut di papan-papan tanda di jalan-jalan raya di negeri itu, sama 100% berpendapat bahawa kita harus menutup sekolah-sekolah jenis tersebut dan menyekat sama sekali penulisan papan-papan tanda dalam bahasa-bahasa itu. Sekiranya tindakan-tindakan ini kelak bertentangan dengan artikel 152 perlembagaan, maka kita harus merombak perlembagaan tersebut demi kepentingan rakyat. Kalau kita gagal melakukan hakikat ini, bermakna kita menghampakan amanah yang diamanatkan oleh rakyat dan juga melenyapkan harapan dan aspirasi generasi baru kita yang tidak mahu melihat negara mereka dicap oleh identiti orang asing.
Hi, Mr. Chan. Please welcome. Please take a seat. Why are you so angry? You know what, Mr. Chan? Just now the speech, Mark Coding, he mentioned a lot of words is against the Sedition Act. How can that man who about the policy of government allowing Tamil and Chinese language to be continued in Malaysia. Not only that, Mr. Chan, he also questioned about the use of two languages in signposts. Seriously, it can be a racist issue. What do you think about this, Mr. Chan?
But before that, we should collect the evidence first.
Yes, sure. We can get the evidence from the typewriter.
Okay, go.
Good afternoon.
I'm Mr. Chan.
What can I help you, sir?
Can I get the report of the speech by Mark holding in this morning?
Yes, can you wait for a while? Here it is.
Thank you.
Please come in.
Good morning, ASP.
Yes, what can I help you?
Actually, we come here to do the police report against the Mark holding.
What report?
Actually, the evidence all is in we already filed in the report. I think you can have a look.
Can you explain more further about the report?
Actually, there's Mark Korean this man actually question about the policy government of allowing Chinese and Indian schools, okay, to continue in this country, and also he got questioned about the use of Tamil and Chinese language in the signboard. So actually, all the speech is against Sedition Act. So we are here to do a report.
Yes, I will help you to report this case.
Thank you.
When there is an issue arise against law, of course there must be a judgment and punishment. Let's see you all in the court.
Here has a small introduction about the Sedition Act. The Sedition Act 1948 is a law prohibiting discourse deemed as seditious in Malaysia. The Act defines speeches as sedition tendency, including inciting hatred or contempt or provoking dissatisfaction with others, or creating feelings of abuse and hostility between races. So, can you more explain about this act?
As I start with explaining the history of the Sedition Act, how the Sedition Act come this country. First of all, the Sedition Act was introduced by the British colonial government in 1948 to use against local community insurgency. Human rights group accused the government Barisan Nasional prohibiting of expanding the scope of the law since it gained independence from the British 5 decades ago. They say the definition is now too vague. The law was introduced by the British in 1948, the same year that the Autonomous Federation of Malaya came into being, with the intent of curbing opposition to colonial rule. The law was retained in the status book independently in 1957 and merged with Sabah, Sarawak and Singapore from Malaysia.
Okay, I add some points. The Federal Constitution of Malaysia as well as the subsequent Malaysian Constitution allowed the Federal Constitution to impose restrictions on the freedom of expression granted to the Constitution. After the May 13 incident, when ethnic unrest in Kuala Lumpur killed at least 200 people, the government amended the Constitution to expand restrictions of freedom of speech. The May 13 incident caused 196 people dead and 439 people injured. In this incident, there were a total of 9,143 people arrested and 5,561 people charged, where 45 of who were charged for murder.
So, can you explain about the legal point and the section of this act?
actually, if you look at Sedition Act is actually to raise the discontent, or it also to raise the disaffection amongst the subjects of Yang di-Pertuan Agong, or the ruler of any state, okay, or amongst the inhabitants of Malaysia or of any state, or to promote the feelings of ill will and hostility between different races. Okay, so when we look further, according to the legal proceedings, no person shall be prosecuted. Okay, no person shall be prosecuted for any offence they have done under Section 4. Okay, where without the written contents of from the public prosecutor. So, for instance, when you look at the case, public prosecutor versus Marcoding, in that case, Mr. Chan and then Mr. Patmanathan, before they bring this case to the federal court, they get written evidence from the typewriter. So actually, these are some examples. Besides that, Section 2, okay, it creates the tautology that the word sedition, when paired with a verb or a noun, qualifies that the noun or verb as having a seditious tendencies. Next is Section 3, subsection 1. Describes sedition tendencies as including a number of extremely broad categories of consequences that could render otherwise legal acts illegal. In the last section, Section 4, subsection 1b, it specifies that only the means by which the offence of sedition can be committed, such as publishing, printing, selling, possessing, distributing, or reproducing any seditious publications, or uttering any seditious words. Okay, for example, under publishing, we can give some example based on the case public prosecutor versus Mat Suhaimi, where Mat Suhaimi bin Shafi published a provocative publication on the srimuda.blogspot website, which has a web address HTTP and so on. And then another case under the printing is, as I said earlier, public prosecutor versus Mat Coding.
So, what is the effect of Youth Citation Act? Can you please explain to us?
Okay. The Sedition Act 1948 is the best law that's more helpful and useful to the public. There also have some effect in use of Sedition Act 1948. The first effect of Youth Sedition Act 1948 is able to maintain its multiracial unity. Malaysia is unique in certain ways due to its diversity in race, ethnic, religions, and customs. It is not easy to ensure unity and stability in a country with many race, ethnic, religions, beliefs, and customs like Malaysia. Malaysia relies heavily on law, rule, and procedures to ensure harmony, a route for maintaining stability and unity in the society. Albeit the main objective of the Sedition Act with the core spirit of the law, which is to maintain harmony among Malaysia for different race and religions. Sedition Act was adopted in 1948 by the British in Malaysia, and it has continued to exist in its original form unity today. Sedition Act has become one of the best suited acts to help in these countries. The second effect of Youth Sedition Act 1948 is control the public speak about sensitive issues. Living in a multiracial, multi-ethnic, and multi-religional community, we are exposed to various and many sensitive issues which could create ill feeling and dissatisfaction and could finally end up in a tragedy. Malaysia has faced this incident in May 1969, where the government had to declare emergency order. Malaysia took serious consideration and action for any inclination of any other incident of such ever since this race riots in 1969. Create a more peaceful, stable and harmonious country is also one of the effects of Youth Sedition Act 1948. People convicted of sedition speech can be imprisoned for up to 20 years under the proposed Sedition Act amendment with a minimum jail term set at 3 years.
So what is the factor of use of this act?
Okay, first, after the event of 13 May 1969, the Sedition Act was tightened for the purposes of national stability. Since the amendment of the Act in February 1971, the government strictly enforced the law and prosecuted anyone who questioned about the citizenship status of the non-Malays, national language and other community language, and also Malay special rights or other races interested. The Sedition Act 1948 appeared because it gives justice to the people. When any person is affected by others, it will help them to get justice. It also allowed people have brave to handle any situations that happen in their life. The Sedition Act helped to control the speech of the people. Malaysia is a multi-race country. In the Malaysia country have Malay people, Chinese people, Indian, Iban and Christian and many more. The Sedition Act mainly because to keep the harmony and the peace of the people in the country. It also avoid people talk about sensitive issues. For example, the Malaysian government avoid the 13 May 1969 issue to happen again. This Sedition Act become a security to the people in critical situation. Other than that, by having Sedition Act, the people can avoid from reputation damage and avoid fake news spread in the social media. When the person not do any mistakes, the person can report this case in the court. They also get compensation from the plaintiff. This is the main reason the Sedition Act more important and helpful to the people.
Let's discuss about the Sedition Act cases.
Let me start with the case. The case is involved Matswaimi with Shafi versus public prosecutors. In this case, the plaintiff is Matswaimi bin Safi and the respondent is the government of Malaysia. The respondent was charged at the section code under section 4 subsection 1C of the Sedition Act 1948, publishing an article online entitled "My opinion is based on the Constitution of the State of Selangor 1959." On 7 February 2011, Matswaimi bin Safi, a Malaysian politician and member of the State of Selangor, publishing an article online entitled "My opinion is based on the Constitution of the State of Selangor 1959." Publishing an article online entitled "My opinion is based on the Constitution of the State of Selangor 1959." On 7 February 2011, Matswaimi, a Malaysian politician and member of the State of Selangor General Assembly, was charged with publishing allegedly sedition material for a December 2010 blog post. Matswaimi was published a provocative publication on the website Sri Muda blog post, which at the web address http://srimudablogpost.com. An article entitled "My View Based on Selangor State Government Act 1959." Before the trial took place, Swaimi filed a notice for motion with the trial court seeking to have the charge stricken from his record on the ground that Section 4 of Malaysian Sedition Act, the provision under which he was charged depend on the dismissal for any ministerial element typically required to provide claim to the charge. However, before the commencement of the trial, the respondent had by a notice of motion filed in the High Court should certain order inter alia for the charge against Matswani to be struck off on the ground that 4 of Act 15 was inconsistent with Article 10 of the Federal Constitution. The motion was dismissed by the High Court and the respondent appeals to the Court for Appeals also dismissed. The respondent application for leave to appeals to the Federal Court was subsequently withdrawn in the light of the decision in Seo Chung Peng versus Public Prosecutors, which held that the Federal Court had no jurisdiction to entertain any further appeal that arose in relation to the criminal case filed in the section code. About the issue about this case, in considering this case, the following fact must first be highlighted that the Sedition Act 1948 is a pre-independent law. The validity of the Sedition Act 1948 comes under the saving provision in Article 162 of the Federal Code on existing law, which provides that the existing law shall continue in force after the independent day. In Article 4 of the Federal Code state that is the supreme law of the Federation, and any law passed after independent day which inconsistent which it shall be void. Independent day fall on 1957. Now, since the Sedition Act 1948 was enacted in 1948, therefore, any application to change its validity for being consistent with the Federal Code must be dismissed as it is grounded to the wrong premise. Therefore, the application claim on the first issue shall be squeezed.
We have some offense of accused. December 30, 2010 at the People's Service Centre, 6/2 Vanilla Angry Road, R31/R, Kota Kemuning, 40460 Shah Alam in the state of Selangor, Darul Ihsan. Matswani bin Shafi'i published a provocative publication on the srimuda.blogspot website, which has a web address http://srimuda.blogspot.com. An article entitled "My View is Based on the Selangor State of Government Act 1959", like appendix, which contains provocative verses as outlined, and therefore you have committed an offence under Section 4, subsection 1c of the Sedition Act 1948, which is punishable under Section 4, subsection 1 of the same Act.
Judge George Varghese bribed for the majority of a 3-judge panel addressed 3 issues in opinion, like whether the appellant was precluded by the doctrine of res judicata, whether the proportionality test could be properly applied in light to the objective set out in Article 10, subsection 2 of the Federal Constitution, and if the proportionality test applied, whether Article 3, subsection 3 of the Sedition Act can withstand it. Finally, Judge Varghese found that Article 3 subsection 3 of the Sedition Act placed a disproportionate restriction on speech in light of the government's.
So the next case is public prosecutor versus Mark Coding. Okay, in this case, the three issues which is against the Sedition Act, where Mark Coding, okay, in the Parliament, he questioned about the policy of the government in allowing Chinese and Tamil schools to continue in Malaysian country. Second issue is that the use of Chinese and Tamil languages on signboard. Thirdly, the main fault is he suggested that the closure and restriction contravene Article 152 of the Federal Constitution, that the Constitution should be amended in the interest of people and the nation. So during the speech, Mr. K. Padmanathan was there in the morning session. So he objected speech of Mark Coding to the seditious nature of the speech. Then Mr. Chan Tek Chan, the one of the parliament, a member of parliament who had attended the afternoon session of Dewan Rakyat, he take these issues very seriously and he report to the police, and police bring this case to the federal court. So in the court there are some arguments, okay, where under cross-examination Mr. Chan, the complainant, admitted that he was not enraged by typed speech, but Mr. Chan said he left hurt. So regarding this case, the prosecution suggested for lead evidence, where they need a lead evidence, is a main evidence to prove that Mark Coding act against the Sedition Act. So then Mr. Chan and then Dato Padmanathan, as to why they thought the speech was seditious, the prosecution cannot be said have proved the case. So it further contended that under Section 6, subsection 1 of the Act, Mr. Chan's opinion that speech was seditious must be corroborated, and since Dato Padmanathan does not testify, the accused should not be found guilty. So finally, the judgment of federal court against the accused is, from the judgment, the federal court mentioned that the accused speech contained was seditious within the Act will depend. Okay, where firstly on a reading of particular part of it, secondly on a reading of context in which it, thirdly on consideration of context in which it was made. Next, the second passage by accused questioned the policy of government in allowing Tamil and Chinese languages in schools in Malaysia. Moreover, he questioned the use of Chinese and Tamil languages in the signboards. Then he advocated the closure of the schools and restrict completely the use of two languages on the signboards. So in addition, he then stepped further by suggesting that if such closure and restriction contravene, then the Constitution should amend in the interest of people and the nation. So Muhammad Azmi J had a strictly legal point of view when he acknowledged that whether or not such closure is advisable or feasible in another matter to be decided elsewhere, not in this code. So there is nothing unlawful in allowing Chinese or Tamil schools to continue. By actually this is mentioned by Muhammad Azmi. Then there is nothing. The court decided that there had nevertheless been a breach of Section 3, subsection F, by suggesting the amendment to the Constitution to allow the abolition or closure of such schools for the discontinuance of the use of languages and road signs. So it is a basic principle that eventual decision in a case depends on the specific facts that are before the court when the decision has to be made. So this is even more so when it comes to the sedition. As stated in the study of the law sedition in India, the dimension of freedom of speech as a right is not rigid, but a variable on depending upon a time, place and circumstance. The extent of the right depends, amongst others, on the following factors are the political situation of the times. So, it will be out of place to say that when touching on sensitive issues, it may not be a matter of strict legal interpretation,
alone. So given that social, cultural and other sensitives are involved, there is a definite need to be exercised broader kind of wisdom.
So the last question, what is the criticism of this act?
Any criticism of the government would be seditious. Any comment made can raise ill will and hostility within the population. What is said or done may even be justified, yet would still fall foul of the act. For example, the critics accuse the government of using the Sedition Act to intimidate and silence an opposition movement that is threatening UMNO's hold on power. More than a dozen people, who mostly opposition politicians including leader X, have been investigated, charged or convicted for the sedition this year. So the former Prime Minister said that he announced at the UMNO Party General Assembly that the Sedition Act would stay. As Prime Minister, I have decided that the Sedition Act will be maintained, he said. He added that the law will be strengthened and made more effective after feedback from UMNO supporters, non-governmental groups and other Malaysians. New clauses will be added to defend the sanctity of Islam and penalize those who call for the separation of Sabah and Sarawak states from Malaysia.
Thank you for sharing today, and that's all for today. Thank you for watching and see you next time.